As it turns out, there was more in the decision, and it had just broken when we went to air yesterday, than we really knew. And I'll paraphrase it from Andy McCarthy's National Review piece, where he said, okay, it's for sure they held that states are not empowered by the 14th Amendment to remove alleged insurrectionists from the ballot. That is clear. All 9 agreed on that. States can't do it. Can't have the patchwork of Colorado finding differently than, Georgia, Florida, et cetera. And then 5 of the justices went on to say, the only conservative who didn't join in this is Amy Coney Barrett, that this insurrectionist piece of the 14th Amendment can only be enforced against someone who's been convicted of an insurrection, who has been convicted of an insurrection. And that is the piece that drove the 3 liberals nuts. So they wrote their own decision, Sotomayor, Kagan, and Ketanji Brown Jackson, saying, you went too far. I read this to the audience yesterday. There was no reason to get to that. And you shouldn't have gotten to that. And the reason they're so mad about it, Mike, is that what this does is it makes it impossible for Congress, really at any point, at any time that's going to affect Trump, to invoke this clause against him again. Because the majority of the Supreme Court said this piece of the Constitution, the 14th Amendment, saying you can't run if you're an insurrectionist, can only be enforced against someone convicted of an insurrection. And Trump hasn't been convicted. He was impeached for things in the House. He wasn't found guilty in the Senate. He hasn't been indicted for insurrection anywhere. And so this really was even better for Trump than at least we first thought when we looked at it yesterday. What do you make of it?
Well, the Supreme Court's exactly right, and they're following a precedent from more than 150 years ago called the Griffin's case. And it's not a controlling precedent, it's a persuasive precedent where then Chief Justice Salmon Chase, riding circuit as a circuit judge, not a Supreme Court justice, decided a case where it was these exact patterns where someone was they were trying to disqualify a Confederate who engaged in insurrection or rebellion, and Salmon Chase said no. In order to do this, Congress has to pass a federal criminal statute for insurrection or rebellion with a disqualification clause, which Congress promptly did, and it's on the books now. The most updated version was 1948, and it's still on the books. And if Jack Smith or the Democrats want to get rid of Trump, if they fear American voters and they don't want American voters to decide the election on November 5th, 2024, then Jack Smith better get moving. He better charge Trump with insurrection under this statute. He better get a federal grand jury to indict, a federal jury to find guilt unanimously with evidence beyond a reasonable doubt, a federal judge to convict, and that conviction upheld on appeal. That's the only way you can disqualify under Section 3 of the 14th Amendment. You have to ask yourself this: the January 6th Democrats and the Biden Justice Department have spent tens of millions of dollars hunting for insurrection evidence on Trump, and they charged Trump with many other things, but they couldn't charge Trump with insurrection because the evidence doesn't exist. How many insurrectionists go unarmed and into a nation's capital, get to the Senate floor of the nation's capital, and walk through velvet ropes, follow police direction, take selfies, and don't burn down the damn place? January 6th was a lawful protest permitted by the National Park Service that devolved into a riot, period, full stop.
And what Andy says, Dave, is that this means that congressional Democrats would not be able to, on the next January 6th of 2025, right after we've had the election, that was the day they certified the vote, Mike Pence counted the votes, they would not be able to refuse to ratify a Trump victory on the grounds that he is an insurrectionist. The Supreme Court just took that away from them. And this is one of the many reasons why some on the left are very angry at the Supreme Court for this decision, and in particular for that additional step the 5 conservatives took.
Well, first off, good to be with you, Megyn. It's nice to see Mike, so happy for once. I can see why. He's got two he's got two really good Supreme Court decisions under his belt, plus good polling numbers. So congrats, Mike. This is your halcyon period. And I tell my Democratic friends, this is what you get when you listen to Susan Sarandon for your political advice and end up voting for Jill Stein. You get a Supreme Court that doesn't know the idea of judicial restraint. So instead of just ruling on the issue in front of them, they went further. And the one thing I would disagree with, Megyn, is, and I have a lot of respect for Judge McCarthy, but I didn't see that in the opinion where you have to have a conviction for insurrection before you can bounce someone from the ballot. And I read this and the concurring opinions, and here's what how I interpret it is that what the Supreme Court said is that only Congress can enforce Section 3 of the 14th Amendment. Now, there's nothing in Section 5 that says it's exclusive to Congress, but the Supreme Court said only Congress. So if that means that there is someone who did engage in insurrection and was convicted of insurrection, that states cannot bounce that person off the ballot. Only Congress can establish a mechanism. And if Congress doesn't establish a mechanism, then tough luck. Plus,
well, wait, let me just answer that. You're right. I mean, I simplified it for the audience, but what Andy is saying is that right now, the only existing statute that could be used is the penal law against insurrection. That's the only law in the books right now that could be used. And Trump has not been charged as an insurrectionist. So yes, going forward, sure, they could change the law, but you tell me how in a Republican-controlled House, and we all remember Schoolhouse Rock, it's got to go through the House and the Senate and be signed by the president to become a law, they're going to change the law between now and November.
Oh, there is a less than 0% chance they're going to do that. There is not going to be a change. Congress is not going to act. Congress is going to do what they're best at, which is do nothing. So what this court decision did was to also tell federal courts that you don't have the power to disqualify a federal candidate from office because of insurrection. Even if they're convicted of an insurrection, it's going to be up to Congress to create a mechanism to do that. And so that takes the power away from state officials and judges until Congress acts. So that's why it was such a broad ruling, such a powerful ruling by these justices, and why even Justice Amy Coney Barrett said, hey, let's not go this far. Let's use some judicial restraint. But Katie barred the door.
Mike's shaking his head no. Why?
Well, I would say, I think Dave is right that you can have a civil component to this, because the predecessor to this criminal statute on insurrection or rebellion, there was a civil statute. So it could be either civil set up by Congress or criminal. So that's, according to the Griffin's case, it has to be criminal, but there was a civil component to this. That's, he could be right there. I would say this on, could Congress right now, could federal prosecutors right now get rid of people who engaged in insurrection? And the answer is yes. They would have to be charged. Those insurrectionists would have to be charged under this federal criminal statute for insurrection or rebellion with a disqualification clause that's already on the books. Congress wouldn't have to do anything new.
Let me tell you a story about a guy named Leo Grillo. Leo was on a road trip and came across a Doberman. This dog was severely underweight and clearly in trouble. Leo rescued the dog and named him Delta. Sadly, Delta was just one of many animals that needed help, and this inspired Leo to start Delta Rescue, the largest no-kill, care-for-life animal sanctuary in the world. They've rescued thousands of dogs, cats, and horses from the wilderness, and they provide their animals with shelter, love, safety, a home, dedication, and everlasting love to animals. That's Leo's mission and his legacy. Delta Rescue relies solely on contributions to stay open. And if you want caring for these animals to be part of your legacy, speak with your estate planner, because there are tax benefits too. You can grow your estate while letting your love for animals live well into the future. Check out the estate planning tab on their website to learn more and speak with your advisor. We call dog a man's best friend for a reason. You can help those who need it most. Visit deltarescue.org today to learn more. That's deltarescue.org. Hey, thanks so much for watching. If you like what you just saw, hit the subscribe button for more clips and full episodes.